Imagine that you are a police officer during a night shift. You then receive a call from a woman. She's crying and repeatedly begs for your help, but suddenly the call cuts off. After managing to find the location of the caller, you, together with two other officers, rush to get there. As you arrive there, one officer knocks on the door, but no answer. Fearing for the life of this woman, you smash the door open and make entry into the house. As you move further to the bedroom, you see a middle-aged man passed out on the bed. A woman that had been hiding in the corner of the room suddenly jumps out. As you grab her, she's shaking and crying. You notice bruises on her eyes and neck, as well as on her arms. As you lead her out of the room, she identifies the man on the bed as her husband, and she tells you that he had been punching and kicking her for almost 6 hours. She also says that he had threatened to kill her if she would use her cell phone or leave the house. As you walk out, you see clumps of this woman's hair lying around the floor of the bedroom. The husband is then arrested. A few months later, the case comes to trial, but there is no victim present. The defense and all the witnesses for the prosecution are ready. So, what happens next? Can the case still proceed without the victim? Victimless prosecution, also known as evidence-based prosecution, is when the perpetrator is convicted without cooperation of the alleged victim. This means that no evidence is directly brought up from the actual victim. Prosecutors can instead rely on different evidence, such as call recordings, child or neighbor witness statements, medical records, or police reports or restraining orders, instead of the statements from the victim. This process of victimless prosecution is already widely used in the American legal system, but is yet to be adopted within the UK as a mainstream practice. It is only within recent years that the Crown Prosecution Service has developed a more proactive prosecution approach, and victimless prosecution has become more common, such as the imprisonment of a 24-year-old man in 2016 who had assaulted his girlfriend and stopped her from wearing makeup. The Crown Prosecution Service in particular has focused on the use of technology such as police body-worn video footage and 999 calls where appropriate. While victimless prosecution is not explicitly mentioned in the legislation, there are certain provisions that allow admission of certain evidence into the courtroom. Section 114 of the Criminal Justice Act 2003 enables the admission of a statement not made in oral evidence if the court is satisfied that it is in the interest of justice. Section 116 allows exceptions for witnesses who are unavailable for specific reasons, including fear. This can include fear of physical injury to the victim or to another person, or fear of financial loss.
Another factor to consider will be the UK's current obligations to the European Convention of Human Rights. Article 6 under the Convention states that everyone is entitled to a fair and public hearing, i.e. the right to a fair trial. Article 6, subsection 3d says that everyone charged with a criminal offence has the minimum right to have examined witnesses against him and to obtain the attendance and examination of witnesses on his behalf. The purpose of this article is to ensure that the perpetrator has a fair chance to build his defense, which requires that the defendant has the opportunity to question evidence that the prosecutor holds against him. This means that the main evidence that leads to a conviction can't be the actual victim herself, since the defendant cannot respond to the statements made by the victim.
One common public interest factor to keep in mind is the fact that a successful prosecution is likely to protect the victim from further abuse. Detective Chief Inspector Phil Gall of the Humberside Police, who was involved in the believed to be first conviction for coercion control offences using victimless prosecution in the UK, said in an interview with The Telegraph that It is in the public's interest to progress the investigation, regardless of the victim's wishes. In the year ending March 2018, the Office for National Statistics estimated 1.9 million adults aged between 16 to 59 had experienced domestic abuse in England and Wales. According to the annual report on the police response to domestic abuse, the police recorded almost 600,000 domestic abuse-related crimes during the year 2017. Despite this, about two-thirds of investigations did not proceed due to evidential difficulties, where the victim did not support action. This is an increasing proportion compared to the previous years. Perhaps the most obvious counterargument for the use of victimless prosecution is that to continue prosecuting the abuser may go against the wishes of the victim, who has explicitly stated that they do not wish to do so. It has been acknowledged that domestic violence itself is very different from other types of offences, meaning that its connection to family and intimacy makes it more personal for the victims when compared to one-off offences by a stranger. Enforcing the prosecution, the paternalistic nature of the legal system is further demonstrated, and the masculine solution of criminalization is further relied upon. A study found that when victims were able to drop charges, they reported less new violence, indicating that allowing the victim to do so gave her the power she had previously not had to take control of her relationship events. Without undermining the severity of domestic abuse or the struggles of victims who are genuinely trying to leave the relationship, it must be pointed out that a study found 40% of heterosexual women who reunite with their partners are able to get the violence to stop. Returning to the partner and experiencing an improvement in the situation may not be possible if the partners have been imprisoned as a result of victimless prosecution, and further prolonging the working toward a healthy relationship. Furthermore, mandatory policies may place too much pressure on prosecutors and alienate victims, reducing the victim's willingness to call the police when domestic abuse occurs and exposing them to future danger. The lack of support from the victim means that prosecutors often have to rely on visual evidence. On one hand, the use of images or video evidence is seen in a positive light, as it has the power to allow jurors to feel the emotion of the incident, furthermore allowing them to empathize with the police officers at the time of the incident. This is particularly when body-worn camera footage is viewed in the courtroom. The authoritative gaze of criminal justice is implicitly masculine, and therefore the use of images brings an emotive element into the courtroom, providing balance against the masculinity that is typically demonstrated. On the other hand, victimless prosecution itself means that the victim does not have a say. So what if the victim does not want graphic images of their own battered bodies projected in the courtroom for all to see? Domestic violence is a deeply emotional and personal situation for the victim, and one may consider this to be a humiliating invasion of privacy, given the lack of consent.
Therefore, victimless prosecution has the potential to convict more domestic abuse offenders in the UK and counteract against negative experiences that may make victims reluctant to press charges. There are also lots of opportunities to gather evidence. There are text, receipts, and financial abuse. There are friend stories. There are all kinds of things that will help to provide evidence of what was going on. However, other considerations must be made, such as long-term safety and benefits to the victim, as ultimately it is the victims that these laws aim to protect.